Historically, the Act doesn't actually say that there should be 3 members from the President's party or one party and 2 from the other, but the way it does for other New Deal agencies, but it has evolved that way. But for the first 17 years of the Act under Presidents Roosevelt and Truman, everyone who was appointed was either a government civil servant or government official or an academic. Starting in the 1950s, there were more appointments, and it was President Eisenhower who began this, of management side attorneys. And the management side attorneys who were appointed in the 50s, 60s, and 70s were generally people who had come from what I would call mature collective bargaining practices, where their clients recognized unions, bargained with unions, dealt with unions. At the Democratic presidents who were appointing Democratic nominees continued to appoint government officials and academics during that period. Starting in the early 80s, the blend of management side attorneys changed. President Reagan appointed several attorneys who had more experience and maybe even exclusive experience in union avoidance terms rather than in representing collectively bargained clients or collective bargaining disposed clients. By the late 1980s, the AFL-CIO took the position that if this was the way the board was going to go, they wanted union side lawyers appointed when Democrats became inhabitants of the White House. That is what happened. The first 3 appointees of President Clinton were former union side attorneys. So we now have a board which tends to be more polarized in terms of the background of its appointees than was true when the Act was conceived and then was true for the first many decades. It does not follow from that the board itself has to be polarized or politicized. To give you one example from our neighbors across the pond in Britain, their equivalent of the board, the Central Arbitration Commission, actually has rosters of management side and labor side attorneys plus a neutral, and they sit on 3-member panels. All of their decisions are unanimous, and they've been reversed, I think, 3 times in 8 years by courts. So it's not true that simply because you come from a union side or a management side practice background, you are incapable of reaching a consensus. Regrettably, that has been too often the case under the NLRB system, and there are various theories for why that, in turn, that level of really increasingly intense polarization has gone on.
Okay. Can we expect the polarization to continue for some time, or are there signs that we might have some hope that it won't be as polarized? Well,
I think that the recent process with President Obama's nominees, and in particular with Craig Becker, is an unfortunate signal in terms of the perception by the Republicans that this Democratic president wants to be polarizing. I think his view was, as I understand it, that yes, Becker was a union side lawyer, but he was also an academic and somebody who had litigated a lot of cases and was a more moderate person than they evidently think he is. I think that we are several steps from being able to remove politicization from the board or polarization. One step would be more bipartisanship in the oversight and review process, possibly returning, as former member Walsh did, to having individual members rather than packages. When we have packages, one of the things that happens is that each side feels it has to get theirs, and that tends to reinforce the polarized nature of the board.